Welcome to Hold My Reg, a Quill and Sword podcast brought to you by the Administrative and Civil Law Department at the Judge Advocate General's Legal Center and School. Administrative law may not always make the headlines, but it is the invisible force that maintains discipline, ensures fairness, and ultimately keeps our military running smoothly. Get ready for another insightful discussion, and we hope you enjoy this episode.
I'm your host, Lieutenant Colonel Hans Zeller, and today we have the distinct privilege of having with us Colonel Danyele Jordan, Legal Advisor to the Army Inspector General, and Dr. Herman Walker, Chief of the Army IG's Whistleblower Division, and we will discuss whistleblower reprisal allegations. So, ma'am, Colonel Jordan, you reached out to me here at the Judge Advocate General's Legal Center and School to share some observations and provide some recommendations from your vantage point at the DA Office of the Inspector General, and in particular, regarding whistleblower retaliation allegations and how they are investigated. And your thoughts on this topic prompted this podcast episode. So would you or Dr. Walker care to summarize for our listeners what's on your minds and what would you like to share with us today before we jump into it?
Yes, first I'd just like to say that for several years I had interactions with IGs. But once I got to the Department of the Army level, I was able to finally see things on a larger scale. And I was able to also see that there was so much about Inspector General activities, particularly whistleblower reprisal, and the statute that's at play here, that I never knew when I was out in the field. But at this level, not only do I see a lot of them, but I see a lot of these investigations and legal reviews that could use some help. And as I engaged with the attorneys in the field, I discovered that there just was not a lot of resources available or knowledge about this area. And so instead of just complaining about the problem or admiring the problem, I said, well, hey, this is something that we can actually do something about. So let's get the word out, get some information out. And my goal is I have 4 things I'd like to do today. The first is I want to familiarize judge advocates with the concepts of whistleblower reprisal and restriction, key terms and authorities. And then secondly, I'd like to explain what's required to substantiate or not substantiate each one of these offenses. Then I'd like to share some of the common problems that I've seen in legal reviews for these specific types of investigations. And then finally, I would like to talk about some of the resources that are available for judge advocates who find themselves out at a camp, post, or station without any assistance, that they'll have something that they can learn by listening to this podcast that will help them along.
All right. Could we start then with some background and definitions maybe? What is a whistleblower, right? Why are they given special status compared to others in the Army who make allegations of wrongdoing?
Well, Colonel Zeller, the basic definition of whistleblower is someone that's reporting wrongdoing or some sort of misconduct. And when they do that, then the persons that are, considered suspects or subjects of those particular allegations may have a tendency to want to get back at that person and want to do something in retaliation. And so with that, specifically to what we're talking about today, a military whistleblower is any soldier that reports significant fraud, waste, abuse of authorities to either a member of Congress, to an IG, or to some office or authority figures that's specified to receive those particular kind of complaints. And what I mean by the designated personnel is, through the chain of command to say if they're SHARP or sexual harassment assault response program personnel, EO, military authorities, military police authorities. And once they make that particular communication, then that's considered, they become what we call a whistleblower. And one of the reasons why they're given the status is because within the Army, we're not given the normal protections for, freedom of speech that others might enjoy because of UCMJ and also the nature of what we do, confidentiality, things like that within our work. But we still want to have an avenue for them to be able to express anything that might be counterproductive to the organization, to what they're doing within their commands, and identify any shortfalls as far as leadership or just something that's going on that's not quite lining up with the principles and values that we all have come to enjoy and want to continue to see moving within the service.
So how long has this idea of a whistleblower and these protections been with us?
Oh, that's they've been around since, you say, the founding of the country, to tell you the truth. In 1777, they're one of the first acts as far as the government stepping in to, say, protect whistleblowers. It occurred, there's an article written where there's like 10 captains on the USS Hudson at one point in time, and they had some problems with their commanding officer. Now, this was, one of the leading generals of the Navy, at the time, the Continental Congress. And because they had no other recourse, had no protections, if they were to come forward, they could even be found treasonous and traitors if they were to speak against their commanding officers. So they petitioned the Continental Congress in order for them to be able to receive the protections of the government. And then, long story short, eventually the person that they were filed the grievances against was relieved of command. And then once he was out of command and out of the service, he filed charges in a civil court, and they found themselves on the wrong end of the law as far as they were now being charged. Two of those personnel were the ones that were arrested actually and were brought to trial. So the government reached out and said, okay, in this case, there's not much they can do as far as redress for them, but they were able to provide the legal fees for them to be able to try their case and work through, so they refund whatever legal costs there were. And so that was kind of like the first indicator that the government wanted to protect that ability for, regular, you say, personnel within the formation to be able to speak against those things that were considered as wrong or counterproductive to the organization as a whole. And then it kind of grew at different levels until now, where we do have what they call the Whistleblower Protection Act, which is is codified within our statute.
Okay, so you mentioned that so now we have a Whistleblower Protection Act. Is that the law that our listeners would turn to if they wanted to see kind of the foundational statutory
Well, if they're
requirements?
they won't necessarily see it as that name. Basically, it's codified in Title 10, Authorities of U.S. Code, and it's in Section 1034, which deals with the military reprisal side of the house. And so that's where all that we do is covered under that particular statute.
Okay, and like lots of statutes, then the service components following DoD's lead often are left to implement, right, whatever these laws are. So can you explain to the listeners where in the DoD then and where in the Army as a component do we then look to our authorities when it comes to whistleblowers?
Okay. As you mentioned, the Title 10 responsibility does lie with the Department of Defense. And so the Department of Defense IG published a directive 7050.06 that covers and implements all the provisions within the statute so that we can begin to operate and meet the intent of the statute. The Army has also implemented the principles and all the rules and regs of the directive in our Army Regulation 20-1, which governs all IG activities. And so there's a subsection within there that deals with specifically with the whistleblower aspect of what we do. And there are a couple of other publications. DoD's published an instruction in addition to their policy reg in order to implement their policy. And likewise, Army, we have what we call an A&I, or Assistance and Investigation Guide, which also helps codify and implement our regulations.
I'd just like to add that the instruction number is 7050.09.
Thank you. All right, so you hear often, right, in our professions about people going to IG with all kinds of complaints. But again, we're focusing on whistleblower reprisal allegations here. So who can, and maybe more importantly, who cannot receive an allegation of whistleblower reprisal? How is it different than other IG complaints?
Well, normally IG complaints, and we do get them from different avenues, but at the end of the day, because of statutory requirement, we have to investigate it within the IG channels as far as any complaints that come from a service member. And some may go to their commands, but it's highly recommended the command will refer that to the IG, and that's because of the special protections that are brought about because of the statutory requirements that we have.
So for our listeners, many who are legal practitioners within the military and the Army specifically, then if they hear of an allegation of whistleblower reprisal and their command wants to go about investigating this on their own, what would your thoughts or advice be?
Well, the advice would be to refer it to the IG.
Okay. All right. And so, on that note, what training and education are provided to the Army regarding all of this, right? What can our commanders and staffs expect to learn about this?
Commanders and staff, they do have an initiative where the TIG, the Army Inspector General, goes to the pre-command course on a regular basis to deal with those commanders. And that's where they begin to talk the process of what IGs do in general. And then this will just be one aspect of what the larger picture is for the IGs.
For legal personnel, it's a little bit more limited. And so IGs go to school for 3 weeks. And in that, they touch upon this subject a bit. They also, the DoD has a mobile training team that they send out, and I know there was just one at one of our installations in New York. And then that IG office invited their legal personnel along, and so I encourage any OSJ out there or legal personnel who are at an installation with an IG, talk and coordinate with them and find out, do they have one of the mobile training teams coming along. And I think the IG may actually start doing the same thing, to go ahead and send some legal personnel to the training. It won't help them on the necessarily the legal side of the house, but what it does do is it familiarizes them with the statute itself and what the IGs are actually charged with doing, so that as legal personnel provide legal reviews, they have the ability to fully grasp and understand the subject matter that they're dealing with.
And what Colonel Jordan is referring to as far as getting to the field and having commands informed, our number one strategy is the local IGs to be interactive and with their commands and be able to speak in different venues. And that is our number one way to get out what the IG does. On the IG side, we do have a 3-week course where 1 week is given over specific to investigations, and a portion of that is covers down on the whistleblower. Then the DoD, they do have their course, as Colonel Jordan has mentioned, where there's a 1-week course. You can go in residence if you're in the area, or you can wait for that mobile training team to come around. And if any legal teams are there, I advise you to at least get in on at least the 1 week of investigations at the TIGS course, and that will help with just everybody having this, knowing what's going on with the whistleblower.
Yeah, no, that would have certainly helped me had I known of that opportunity as a major at some point.
Certainly.
Okay, so we talked a little bit earlier, Dr. Walker, what is a whistleblower? What does that mean? And what are some other important definitions or terms of art that our listeners should be familiar with, right, as they're advising commands and staffs and deal with an allegation of whistleblower reprisal?
Well, a couple of things is when you're dealing with the statutory definitions and what's theirs, it's the difference between restriction and reprisal. Those are two aspects that's important to understand when it comes to whistleblower. The restriction piece is where Congress has said that it's so important that we hear from personnel that's want to report wrongdoing, that no one is allowed to restrict them from talking to a member of Congress or an inspector general. And so that's where the statute ends there as far as a restriction side of the house. Then we talk about reprisal. Once that person does become a whistleblower, that's where those protections are invoked, and so now they become protected, so that they have the ability to speak freely without expecting any form of retaliation or reprisal. And a lot of people get caught up in what's retaliation versus reprisal. The reprisal is a subset of retaliation. So the key terms are protective communication, which I just explained, is if they talk to the IG, member of Congress, or designated personnel. And then we deal with the personnel action. Those are things that affect the service member's pay, benefits, or their career. And so if those things are in place, then that's where it falls into the line of being a retaliatory or whistleblower reprisal action. Versus if it's something, for a soldier's sake that the command is now ostracizing them, or otherwise giving them menial tasks because they've reported some wrongdoing, that does not fall under the window of reprisal, and that's where the command would look into more retaliation than they would the reprisal aspect.
I'd just like to add a little bit to that for judge advocates, it's going to be very important that they are close to and talking with their IGs and the command teams, so that they can also understand when an activity actually rises to the level of criminal misconduct, because that may need to go to CID. So when you start getting threats that are made in retaliation for a person making a protected communication, or things are starting to get dangerous, then you want to move it away from IG and move it into CID.
Okay, so let's move on then. Thank you for sharing some of those thoughts on definitions. When an allegation of whistleblower reprisal comes to the IG, right, and the recommendation, right, the advice is it certainly should, if that kind of allegation is made, refer to the IG. What goes into a decision by the Inspector General's office to open such an investigation?
Well, the first thing we do is look at the complaint, and then we try to identify what we call prima facie. That means at first glance, does it look like reprisal? And the elements of reprisal we look at this stage of it, we're just evaluating the complaint. And so we assume that what the complaint brings to us, if it's true, would it meet the elements of proof for reprisal? First being protective communication. because they have to have qualified as a whistleblower in order for us to even begin the process. And so we determine if it's true, did they make a qualifying protected indication to the correct personnel, whether reporting something, wrongdoing that a reasonable person will consider as something that's, wrong or egregious. The second part of that is that we look at, did the person they alleged took some personal action, did they know that they went and made the protected communication? And then after we establish that they say that, that they did know, then we look at the personal action. Was their personal action actually taken? Was it threatened? Or what is the complainant bringing to us as far as aspects of that personal action? So if those three things are in place, we also have to consider a fourth thing as far as timeliness, because there are timelines tied with complaints that come through the door. When we have all those three in place, PC, PA, and I'm using the acronyms, and then we have the knowledge of the suspect in the case, then those are things that we would say that's enough warrant for us to go forward with an investigation.
Okay, so I'll get into kind of the meat and potatoes, if you will, now of what we're going to talk about today. There's maybe a lot to unpack here, but I thought it might be helpful for the audience if we talk a little bit about how these investigations that we're talking about today differ from Army Regulation 15-6, Chapter 5 investigations, which I think a lot of our audience is familiar with. So can you talk a little bit about that first? How are these different than, I think, the investigations many of us know about?
Sure, and I'll go ahead and jump on that one, Colonel Zeller. So first, I'd like to say that one big difference between 15-6 as a regulation and AR 20-1 and the Department of Defense regulations that govern IG investigations is confidentiality. If you do a word search, you'll see it 90 times in AR 20-1, but you won't find it not one time in AR 15-6. And so that concept is a core concept for the Inspector General system. It's key to the integrity of the system. It's one of the reasons why those who feel aggrieved, why they come, because they know that their identity will be protected, that they have this level of the confidential nature of their conversations with the IG. And also the statute itself, 10 U.S.C. 1034, requires that for IGs, they must treat information they receive in official communications as confidential. And they have to treat it with the utmost discretion. And so you find that with that backdrop, that the rest of the regulatory provisions kind of nest under there. So with an IG investigation, right, it has to be, well, first of all, with the Whistleblower Reprisal investigation, it has to be investigated by IGs. You're also going to see that who can appoint an investigation is different. In 15-6, a lot of commanders have the authority to appoint, and judge advocates are very familiar with that. But in 20-1, there's only a directing authority, which is generally at the local level. It's a commanding general with an IG on his staff. That's it. So where 15-6 has a variety of people that they can appoint and a variety of people who can be appointers, it's very limited under 20-1. In addition, there's no flagging that occurs with an IG investigation. Command investigations require flagging. The 20-1 does not. Another thing that you got to see is that, of course, for anything dealing with the UCMJ, it's not going to be applicable to civilian supervisors. So if they have committed some misconduct, they're not going to fall under the 15-6 Chapter 5 retaliation reg, but they could actually fall under the Whistleblower Reprisal 10 U.S.C. 1031. So those are some of kind of the big things. Another thing that I know judge advocates are often surprised by when I talk to them is that in 15-6, if there's got to be an adverse finding, that investigation to that point is going to be referred to the suspect or subject, and they're going to get a chance to kind of make a comment or reply to that information before the appointed authority makes a decision and approves or doesn't, makes a decision on the investigation. But in AR 20-1, with the Whistleblower Reprisal IG investigation, that information is not going to be referred. And so they will have a chance to consult with an attorney, and the person will have a chance to speak and make a statement, but they will not get a chance to see everything that has been provided so far against them.
All right, thank you, man. Those are some pretty big differences. Did you have anything, Dr. Walker, you wanted to add?
No, just on the, like I say, when you're looking at 20-1, just understanding that there are differences is one of the big things that we want to just reiterate as we go through. And then terminology, as we talked about, as we kind of mentioned, I use the term suspect because that's what we do for reprisal. The accused are considered suspects, and that's why we give them the rights warning, because it is punitive by UCMJ. Whereas the 15-6, you can have a person as a subject. And so just knowing the difference between those two words and how we use them becomes important.
Okay, how about timelines? And I think that was already mentioned earlier. Are investigations subject to AR 20-1 procedures, subject to any timelines? And is that left to the discretion of the appointing authority or somebody else?
Well, by the regulation, we have 1 year, and that's by statute as well. It's 1 year from the time the last personal action that the complainant is complained of. They have 1 year to file a complaint with an IG. And then it is, at that point, this discretionary in the sense that the IG has determined why they didn't come forward any time before now. Was there something compelling to keep them from coming forward? Were they misled? Did they file with the wrong office? All those type of things. So make a concerted effort to make sure that there's nothing that impeded them, because we also talk about the restriction side that could have been a part of the process. But once we made a determination that there's nothing that prevented them from coming forward, then we basically will close without action at that point in time, because it's just been too long. But on the other side, for restriction, there's no timeline. You can come and report restriction at any point in time.
And how about the investigations themselves? Once investigation begins in IG channels, are you yourself subject to any kind of internal timelines, or again, is that just subject to your own policy?
No, by statute, there's a 180-day requirement. Once we did make that determination that we're going to go to investigation, then we have 180 days in order to provide a report back. Again, the statute says back to Congress. DOD being the operating agency, that's who we give our reports to. However, if we cannot complete an investigation after 180 days, then our requirement is that we have to notify the complainant. We notify, for Army, we notify Secretary of the Army, notify Department of Defense, IG, that we're not going to be able to finish it. We have to give them a timeline as to when we expect to complete that particular investigation.
Dr. Walker, you already, I think, covered some of this, but I think it's worth going over again in a little more detail. What are the elements of a whistleblower allegation of reprisal? In other words, protected communication, personnel action. Could we go over those one more time and just explain what each of those means?
Yes, sure. There's 4 basic elements of proof for reprisal. The first being protected communication, then there's the personal action, there's a knowledge of the suspect in the case, that they had knowledge of the protected communication, and there's causation. And we'll start with the first one, protected communication. We covered that a little bit of reference, where the complainant has to come and report something that they reasonably believe is evidence of some misconduct, a violation of a law or regulation. Once we've established that, then we move, and everything is progressive, and if we can't establish that, then that pretty much would end an investigation. Then we move to personnel action. Did the person receive a personal action that impacted their pay, their benefits, or their career? Once we establish that something happened, either a favorable action that was withheld or an unfavorable action was taken, where they were taking a privilege or something was taken away from them in reprisal. At this point, just identifying the action itself. And if we can establish there was an action based on the evidence, then we move forward to the knowledge. Did the subject or personnel responsible for that personal action, did they know that the complainant made a complaint prior to them taking an action? And then we go to the last piece, which is the most important part of any analysis or any report that we provide, is the causation. What we call it the causation. Would the action have happened regardless of whether that complainant had made a protected communication or not? And so that's kind of the going in question. And so we go through 4 variables in order to establish that. 1, we look at the reason. We have to interview the suspects and we ask them, why did you take the action? And we see whether that balances out with evidence that corroborates or refutes whether they did it in reprisal or not. Then we go to the timing of it. How close was that, the personal action, to the actual protected communication? Like I blew the whistle on Monday, all of a sudden getting action taken on Wednesday. That's kind of close. And so we'd say that infers there might have been some reprisal, tentative reprisal there. but it's been over a year or year and a half, 2 years. Now we're a little less likely that it was something that was done in reprisal because a lot has probably happened within that time frame. Then we can look at the motive. Any protective communication, there's a subject or there's an organization that's impacted by that complaint. Did that protective communication create motive on the part of anyone that was a subject or suspect in that protective communication in order for them to take actions in reprisal? So we evaluate that, and everything is back towards this protective communication. And the fourth and final part of the variables of the causation is disparate treatment. And that's where we look at how did this person treat the complainant prior to them making a protective communication compared to how they treated them after the protective communication was made. And so those are the four things. We walk through that in the process. We analyze all the evidence, and in the final analysis, we determine whether there was an indicator that it would have taken place, even if it did make a protective communication. There's enough evidence for that, or the only reason that the action was taken is because of the protective communication.
I'd like to go back to personnel actions for a moment, if you don't mind. Judge advocates who practice administrative and civil law know there's a really broad spectrum of what amounts to what we would call adverse administrative actions, right? And that can be, again, with something as simple and relatively harmless as referral to ASAP, the Army Substance Abuse Program, for example, all the way up to some pretty heavy hammers, right, when it comes to administrative action, like involuntary administrative separation, right? So again, there's a very broad spectrum of maybe what judge advocates think of as personnel actions that could be adverse. But the definition that you gave us here sounds like it might be a little more limited than that. Is that fair to say? Well, it has to affect pay, for example? Is that
right? And in the end, whichever action, because there are different aspects of even what you're talking about as far as these actions, is the evidence has to show that it has impacted the soldier's pay, their benefits, or somehow is impacting their career progression. And so that's the basic thing. Keep going back to that definition.
So would it be fair to say then maybe that a local company level letter of reprimand, a battalion letter of reprimand that's just locally filed, otherwise doesn't go anywhere, would that not amount to a personnel action within the scope of this type of investigation?
On its face value, no, that would not amount to it, because a local action such as that would be retained at the unit, would not follow that soldier throughout the rest of his career. And at the time, it normally does not impact their pay or their benefits. And so that would pretty much not be counted as a personal action we would look into.
I think that's an important distinction for our listeners, again, because I think as lawyers, right, we have an idea of what's an adverse administrative action, and I think we're scoping down a little bit more with these.
This is definitely scoped, and this is an area where I hope the judge advocates are engaging with their IG counterparts during the investigation, so they can really assert themselves, hopefully, at the beginning of it, to make sure that as the IG is making a decision on whether or not to dismiss, do we have enough here? There's an opportunity to consult, but there's also, or to ask questions to help the IG come up and formulate questions. But this other piece too about these four different elements, these are essential elements, and the judge advocate can really, so it's an area that's ripe for discussion, for debate about what is or is not a favorable personnel action or what's an unfavorable personnel action. Because remember, it can be either withholding a favorable action or given an unfavorable. And sometimes what we find is that a person may have deserved an action that's unfavorable. When I say deserved, I mean that there may be legitimate good reasons why they received it, and it may just be a coincidence in timing that it came after they made a statement, or the person who gave the unfavorable action may not have even had knowledge. And so that's why those elements are so important, because you have to have all of them. If any one of them is missing, then we don't have a reprisal action. So yeah, so this is important. And just so you know too, just to scope it down a little bit more, there's something as simple as a counseling statement that I've seen where there's been errors, factual errors made about whether or not a counseling statement is in fact a personnel action. And if it's just an informative, it doesn't have any threats of action to come, then we know that leaders are required to counsel. So that is not that would not count as a personnel action.
And if I may add just a little bit more on the personal actions, and this is prior to it coming to us in the sense that we're looking at historically, did the suspect actually consult with the IG? Did they consult with legal? Did they consult with, say, behavioral health personnel prior to taking any actions against that service member? Those are considered what we call affirmative defenses, that it was not taken in reprisal, and that gives us, a better window of what actually took place.
Thank you both. All right, I want to talk a little bit about procedure next. I think we've done a great job kind of getting an idea of what some of the important terms are, what the elements are now that make these investigations happen. So what about procedure? Again, something legal advisors are going to be looking at carefully as they work with folks on these kinds of investigations. How is this different than 15.6s, for example?
So I kind of touched on that just a little bit earlier, and I'll try not to rehash too much. But we know that the appointing authority is limited. It's got to be a GCMCA or a state. We call them a TAG, but Adjutant General for a state is going to be the appointing authority, and that's pretty much it. And then, and so of course that's very limited, and there's not a lot of people who can investigate. It's got to be IGs for a statutory whistleblower reprisal, which is the one under 10 U.S.C. 1034. I also mentioned the flagging action. There's a flag for one and not the other. Here's something else, though, that some people say is disingenuous to say the IGs don't flag, because what we do know is that the fact that someone has come under an IG investigation, while the IG won't flag and the commander won't necessarily flag the person if it's an IG that's investigating, if that person is going before a board, a promotion board, or getting a key or nominative assignment, and their record goes through a screen, it will indicate that they are under an IG investigation. And at that point, HRC or HQDA could, in fact, impose a flag. And so although it's not IG that's flagging, the IG action is the impetus behind it. And so in some ways people say, well, it's still because of IG. But just note, though, that would be a DA or HRC or other higher level, and it would not be coming actually from the IG enterprise itself. So those are some of the big differences. I also mentioned that there's no referral. One thing that's similar is they both have preponderance of evidence standard, and in both instances, the suspects are going to have certain rights against self-incrimination. They're going to have all those rights against making a statement or having an attorney that's to advise them and things like that. So some of the oath taking is a little bit different because for IG investigations, they're going to take oaths for anybody taking testimony. So you're going to see some of that. And I think they both pretty much observe privileges, although it's not necessarily required. So this is some good distinct differences that legal personnel should familiarize themselves with, because when we're looking at the legal review, we're going to ask that the legal persons, the judge advocates, that you actually look at whether there are any procedural errors that occurred and what were the effects of those. And you're not required to do that, but it's important. I just say as the legal advisor, senior legal advisor for IG, that is important that if that has happened, that you guys point that stuff out.
Thank you, ma'am. With respect to the tail end of these investigations, are there avenues for appeal, or is there any other kind of post-investigation review under AR 20-1?
Under 20-1 and by all the regulations, the complainant has opportunity if, once the investigation is closed, they get notification, they can go back and ask for another look or a redress. And normally that channel is going through DOD, IG, since they are the ultimate decision makers as far as closing any particular case. And so that's pretty much the limits of who can go through the IG channels in order to receive any kind of redress. Okay,
so, well, that brings up a good point worth mentioning then about the process again, since we were talking about processes a moment ago. So, a complaint is received, say, at the company level. It's then referred by that unit to the IG. We've talked about how the IG will review this, look at these elements, and then on its own decide if it's going to open an investigation. Again, in particular for whistleblower reprisal. The IG will conduct the investigation, is that right?
Yes.
Internally?
Correct. And just one correction in that if there's a reprisal complaint, it has to go to an IG. We don't do third-party complaints on behalf of or anything of that nature. And we don't do anonymous complaints either. So those are key points to make for complainants.
And then at some point that investigation is completed, and we talked a little bit about kind of the statutory timelines to finish those. But you mentioned, Dr. Walker, then that it's ultimately going up to the DOD level. Is that right?
To the DOD level, correct. What happens is at the Department of Army IG level, we're called the Office of Record. And so every subordinate office within the Army for the military cases that we handle, and we only handle non-senior official cases as far as within my division. And so what that means is we don't have, if there's a suspect that's a general officer or an SES or a promotable 06 or promotable colonel, then that will be handled by a different division, our inspections division, which handles all senior official cases. So allegations that come to my office, we will be either we'll investigate it directly at my level, or if a subordinate office investigates, then we do mostly oversight. And so I do mostly oversight within my office, so we look at it, make sure that the investigation has met all the standards that we have as IGs, all the requirements, statutory, regulatory, and all the guidance that we've been given. Once we've signed up on the product, we give it to DOD as a recommended actions, either substantiate, not substantiate, or we evaluate and determine we want to close it. And then they're the ones that do the final approval. And once they give us approval, then we'll take that information, they will do the final notifications to the complainant as well as the subordinate commands for that action.
Actually, Dr. Walker brings up some interesting differences also, is that you notice how there's so many processes that are involved, so many layers of oversight that occurs, and also he says substantiate, not substantiate. That's the only conclusions you can come to is it's either substantiated or not substantiated. Correct. At the end.
Once we go to investigation, that is absolutely correct.
So what is a typical timeline, if there is such a thing, acknowledging that, every case is different, every allegation is different? Do you have a sense for that?
To tell you the truth, I don't really like to talk typical because each case has a life of its own. But if you want to know historical, well, the average right about now for the last year or so, we're getting down about 300 plus days in order to resolve a case, in low 300s. But that's as a progressive reduction in the number of cases that we typically would have as far as time that it takes, because we've implemented more process improvements to where it used to be a high when I started into this. It was like maybe 500 days, and even beyond that, where a case could conceptually be open. And what that meant was that there was somebody on the tagline, either complainant or that suspect, that was being held up from a promotion, being held up from going to a school, and things like that. So we took all those efforts to bring that down. But like I said, right now, today, speaking to you, probably around the low 300s right now.
Well, on that note, what, in your opinions, makes a good AR-20-1 investigation, and what makes a bad AR-20-1 investigation, one that might take a little longer?
Okay. I guess talking in terms of good and bad, I guess the best investigations are ones that address the complaint that was presented. And what I mean by that is a complainant comes to the door with X number of actions that they felt were, there was some wrongdoing, there was some injustice taking place against them. And many times it does include reprisal, but there may be other elements that were not part of the reprisal, or we wouldn't consider it in reprisal. But even in that, when you do a protective communication, there was some wrongdoing in the reporting. Did that get addressed? So we have to address that and say we either refer that to the command for further actions, and IG has to take some action. So that's a part of that process as far as the investigation. And now I'm talking about the report because I mostly look at the oversight. And so addressing all the what the complaint brought to us, and then as far as the IG, analyzing all the evidence and making sure that all the elements of proof are met either one way or the other, and then making a determination based off those elements so that all the findings are supported by the facts that were brought to the case, and not conjecture and not just coming off the top of your head as far as how you come up with your conclusions, and not just making conclusions without being to cite some evidence that's in that particular report.
Oh, thank you. Yeah, Colonel Jordan, again, for maybe many of our listeners, then, in the same vein with legal reviews of these types of investigations under AR-20-1, what does right look like in your mind, and how can a legal reviewer know if the evidence is sufficient?
Sure. So one of the big things that I look for when I see some of the legal reviews is that they don't rehash the facts, right? Because the person who gets the investigation, the report of investigation, those IGs are required to put detailed facts. And so there's no need to go ahead and rewrite those, nor to rewrite all the elements that the IG has already written in their report, right? So sometimes the legal reviews look like a mini report of investigation, and there's really no need for that. there's no need to redo the analysis if the analysis was done correctly and go through all the elements again. The only time you want to really talk facts is if there is a factual dispute and you need to resolve a factual inconsistency that's in the record, or if you disagree with, as a legal advisor, you disagree with how the IG has summarized the facts or the conclusions they've made. That's when you need to address them, right? When there's something different than what I'm going to find in the report of investigation itself. So the analysis, again, if you believe that the analysis was done incorrectly, as a judge advocate, then that's the kind of thing you want to talk about in your legal review. So you want to bring up any factual insufficiency, any legal insufficiencies, any any conclusions that don't flow necessarily from the facts or evidence. If there's issues with the credibility of the evidence, that's important that you discuss that in your legal review. If you're unable to resolve it, talking to the IG. Another big thing is I've been surprised at how many investigations I've seen that started off with 15.6. And if you look at the beginning of 15.6, it says that the 15.6 does not cover, the Army Regulation 15.6 does not cover the IG investigations. And so that's definitely the wrong reference. So we got to make sure we get ourselves into the right references. And as we said at the beginning of this podcast, those are the Department of Defense guides under the 7050.06 or 09, and then the AR 20-1, and then the Statute 10 USC 1034. That's kind of the bulk of what you want. And then if you go to the DoD IG website, they also have a guide for whistleblower reprisal investigations. And that guide is also quite useful to understand all the elements, and basically will give you a rundown of a lot of the things we're talking about right now. The last thing is, whenever there are inconsistencies in the report of investigation, that is where the legal review is going to do some really great work, because at the DAIG level, as we've explained, there's a lot of levels of oversight. And so whether or not the legal review kind of resolves those and then correctly applies or assesses whether or not the IG correctly applied the preponderance of the evidence standard, right? That's what we do as lawyers all the time. We deal with preponderance. We deal with these gray area types of standards. And so to make sure, what does it mean, the greater weight of evidence? We always see 50-51, but we know it's not a science project. It's not a mathematical formula. So how do we get there? Now, another thing that we really haven't talked about, but that sometimes it's out there in the field, so I'll just bring it up right now. And that is, the legal review. Who gets the legal review? Who gets to see the legal review? Does the IG get to take the legal review and upload it to their database? Does it go with the report? Does it go to DIG? Is it deal for DOD? Is DOD the client? Is there attorney-client privilege that prevents it? And so while I can't resolve those issues as the legal advisor to the IG, those issues are resolved through OTJAG channels, because the attorneys in the field who are doing legal reviews actually work under OTJAG and not under the Army Secretariat where we're located. But I will say that if you look at the Department of Defense instruction, it does tell you that there is a legal sufficiency review required. And so the details, they're not required. But what is required is that there is a lawyer who will be willing to say, right after reviewing all the facts and evidence, that this investigation is legally sufficient. So technically, if an attorney puts that in writing, they have met the standard. I will say, though, as legal professionals, it is incumbent that we go beyond that. It is very important that if you have a person who may be substantiated for something that could be a criminal offense, that we do a little bit more. So that's my plug for go ahead and explaining why something is or is not correct, putting it out there. But of course, I am not the legal advisor, and I cannot provide guidance to the field, right? I'm just putting a plug for the value of it if you're able to do it.
Yeah, Colonel Jordan, as an IG that's been in the field, we have had some different scenarios that come up where the legal team were reluctant to give up different product. And I often explain it this way, in the sense that IGs can't do anything except at the direction of their directing authority, their commanding general. So once they get that authority, within 20-1, that gives them the authority in that command to obtain any product, anything they need in order to conduct their investigation. And so that's what their credentials allow them to have, anything that's produced in order to formulate what they need in order to evaluate all the evidence that's coming in. And a part of that evidence will be that legal review as a part of that, who's operating on behalf of that same directing authority, the same commanding general. And so all these products are all brought together in the name of that directing authority. So the IG is not operating independently. Now each IG office is independent of another, in the sense that in my office, I can't direct a subordinate office, IG office, to do one thing or another. So each level has their independent abilities to evaluate and investigate, but I am the oversight for the purpose of, working through the statutory requirements. And so when they get that perspective, many of them begin to see and understand that we're just the hands, I guess, that's operating in order to bring together what the total body is required to do, in the sense that it's an Army product, not just their level of wherever they're at in the formation.
Thank you. I want to talk a little bit about adverse information, and the Army has a program. It's been around for about 10 years now. It started as a pilot program. Now it's well settled. It's called the Army Adverse Information Program. It's been relatively recently expanded now to include all commissioned officers in the grade of 01 and above. And there's 3 gatekeepers, generally speaking, to how adverse information is kind of identified and received and stored by the Department of the Army. One of the gatekeepers is the JAGLCS as the proponent for AR 15-6. So in our Army investigations through 15-6 procedures, if adverse information is identified in one of those investigations, it's typically going to be through the command channel, with assistance from judge advocates, that adverse information will be identified, and what that is, and any commander's comments then will be forwarded up to the Department of the Army and to OTJAG in particular, again for Army 15-6 investigations where that is stored. The other gatekeeper is our law enforcement channels, right? And then the third is the Inspector General, right? The IG channel. So can you talk to us a little bit about how adverse information works with these kinds of investigations?
So I'll just start it, and then Dr. Walker can help me out with anything I miss. But we don't have the AAIP or AIPP or any of that, but we do have a database that is kept at DAIG, and IGs around the enterprise, around the world, can put information in there. And so when there is a screening agency, so whether it's for a board or for command positions, promotions, retirements, nominative assignments, positions of trust like drill sergeant, all those good things, there is, as you mentioned, Colonel Zeller, we are one of the screening agencies, and so we have a department at DAG that does just that. They literally, that's their entire role, is to screen for adverse information that's in our system. And so anytime you have a substantiated investigation, you will have something, a notation, an S, that will come up and will trigger a summary that will have to be written of the investigation's findings. It will come to the DIG legal office. We do a legal review. And then we are also responsible for making sure that the information is properly, that there's no, compliant with FOIA and that kind of thing. Or we release all the information on behalf of DIG. So we usually put a legal review cover memo on it before it goes to an agency. So yes, and that's in there for 15 years right now.
Well, thank you. I would like to know kind of what your thoughts are on the impact of the overall culture and accountability within the Army when it comes to these kinds of investigations. You talked about the history of these. 1777, I think you said, is right, maybe the first recorded instance of a whistleblower type of case and protections given. So do you have any comment on, the impact that the outcomes of these types of investigations have? What do you see?
I have one word: empowering. And the reason I say empowering is because it empowers people without a voice that know that they have a voice that will be heard and their concerns will be addressed within the system. It also empowers those that are accused, rightly or wrongly, of something. The system will also come into place to evaluate whether it's a false or true allegation that's been made. And so with that, it gives confidence in the whole system. As far as the Army culture, there's something there that acts like a trigger. Like if you have pain or something, like you get injury, but you never feel the pain, you will never know that there's something wrong that need to be corrected. So with that voice, that's kind of like indicating where we need to, maybe pay some more attention to in order to fix the body so it's all healthy. So I think that's why this whole process of whistleblowing is healthy for the command and the environment. So there are some things that are actually true injuries, that would hurt the whole Army, versus those things are just, I prick my finger. Okay, those things get a little less attention than, something that's more severe. So that's where I think it's just empowering for the whole organization to stay healthy.
And what about when we get these wrong, right? What's the danger? What are the stakes in play in these cases? Again, thinking about our audience, right? Why does this matter to legal practitioners?
So I get a little bit passionate when it comes to errors, because I see the errors, and that's part of the reason why we're doing this podcast here. Is we're trying to provide information to inform not only judge advocates, but we're also doing with our IGs, because this is significant. It's significant for both the person who believes they're aggrieved, if they are in fact aggrieved, and they don't get any corrective action done for a harm. And remember, there has to be a personnel action. So if they receive the negative personnel action that maybe derails their career, and they've been working hard, and because they've done something they had a right to do, which is raise a safety issue or violation or a hazard, and something important that they've raised, and if they suffer and their career is derailed as a result, and they aren't able to correct their record, and the person is not held accountable, that's not good. And other people are seeing that and watching that, and so there could be a bigger violation later as a result of people not saying anything. They go, it doesn't matter. My voice doesn't matter anyway. And so we got to be careful about that. But on the other hand, I've seen so many people also who maybe were found guilty of something that we look back and say, well, wait a second. Maybe they were just doing their job as commanders. Perhaps they were just enforcing standards. Did we get this right here? Let's take another look at this. Because what are we saying to leaders if we substantiate and hold somebody under an adverse, with a mark on them that says they did something wrong, just for doing something as simple as doing their job? And somebody didn't like the way they did it, didn't make them feel good, they didn't like being corrected. And when you have a standard that's just preponderance of the evidence, it's so low that I believe that it gives a lot of room for error, because it is such a low standard. And then on the other hand, when you have people who may not be as familiar with the statute and the rules, I think that has greater propensity for error. And so we want to get this right for both those who may be harmed, for the health of the Army, but also for people who we want leaders to lead. We do. And so it's important that we do our jobs well, that we are informed with knowledge and information so that we can do this, but not just do it, but do it well and do it quickly. Because while a person is under investigation, there's not only the mental anguish of the unknown for both parties, or all parties, but there's also the issue of the Army can't move people where they need to move them a lot of times. And you may be not able to promote folks. You got somebody who doesn't get to go to school, who needs to go to school. We want people to go to school. So nobody is helped when we can't do our jobs well and when we can't do them quickly. And so that's to me where these kinds of opportunities to discuss are so important.
Listen, I want to both give you the final word here, right? Any other thoughts, concerns, recommendations that you might want to give our listeners today about this very kind of unique type of investigation, whistleblower reprisal allegations and how they're investigated? Dr. Walker, anything that you'd like to leave us with? Any final words?
Sure, COL Zeller. First, just want to thank you for having us on, and hope what we've provided will be useful for the audience, for the listening audience. And first thing I would say is just don't go it alone. Whether you are the commander that's struggling with what actions I should take, go get the help that you need as far as talking to the IG, talk to the respective officials that can actually help you frame informed decisions. Don't be naive in the sense that there are many, many ways to know what right looks like. And so, like I said, IG is just one avenue, but read the regulations, understand what they are, use your NCO support channels. They're normally, pretty good with the regulations. Just continue to ask those questions. And keep it in mind that whistleblower reprisal is unique. Even in the IG community, among IGs, there's a very small percentage of us that do this on a regular basis. And so we say in the field that takes about 3 years to grow an actual whistleblower reprisal investigator. And so if you're not in that category, We don't want to get it wrong. And so that's kind of motivation for me, I guess you could say. And it's also a little bit of job security, knowing that, okay, I still need to, there's still some wrong out there we need to right. So thank you.
I want to say, Colonel Zeller, it's been such a pleasure spending this time with you, Dr. Walker, kind of discussing something that for some people may be quite boring, but for others, hopefully you're listening to this because...
Well, it's boring until it lands on your desk,
until
right?
it lands on your desk, exactly.
And then you're going to need help.
And then you might need help. And so hopefully those listening to this podcast now have a better understanding of whistleblower reprisal and also restriction. Often unknown, but yeah, when it sits on your desk, it's serious. And I hope that legal advisors are now able to understand the implications of what happens when someone is either claiming they are aggrieved or someone who is on the receiving end of that complaint. And so what I hope is that armed with the right understanding of the authorities, the resources, the regulations that are out there, the guidebooks, you now know perhaps that there's a DIG legal office. A lot of people don't even know that we exist. But that, armed with this information, you're now better equipped to at least begin kind of working through these actions if they come your way. And then I'd also like to say for any legal advisors who are out there, once you've done all you can to work through one of these issues, and if you still just don't feel like justice is being served, just know that you can call the DIG legal office. There's a set of attorneys that are up here. We stand ready, and we are available to answer your questions and talk through your concerns. We will do our best to assist you where we can.
And that concludes another enlightening episode of Hold My Reg. We hope you enjoyed our explanation into the world of administrative and civil law. Until next time, this is Lieutenant Colonel Hans Zeller signing off. Stay disciplined and stay informed. Thank you for tuning into Hold My Reg.
This episode of Hold My Reg is brought to you by the Administrative and Civil Law Department at the Judge Advocate General's Legal Center and School. The views presented in this episode are those of the speaker and do not necessarily represent the views of the Department of Defense or its components, the Department of the Army, or the Judge Advocate General's Legal Center and School. We hope you enjoyed this episode. Stay tuned for another episode of Hold My Reg.